Good evening. Yes, you can hear me. That's great. Hi, I'm George Reary with Move to Men of South Central Indiana, and I want to welcome each and every one of you here this evening for this performance, a monologue about Justice John Paul Stevens. And without further ado, we're just going to go ahead and get started, and then we're going to, following the performance, have a question and answer. And following that, there's actually plenty of cookies and a little bit of coffee out there for you all, so plenty of cookies. So thank you very much.
I am a classical violinist by profession, with a little fiddling on the side. And I've played as an individual in many venues, from a Serbian refugee camp as a lone fiddler, to joining a wonderful group of people as we looked out over the footlights of Carnegie Hall. But I remain first and foremost an individual, a citizen of the United States of America. When I was given the words of Justice Stevens, crafted so beautifully as a monologue by Jim Allison, I knew I had to contribute to preserving what our Constitution really means. So today, for a little while, I will become his honor. Now, I can't really become the justice, obviously, but I can offer you a little visual help. Justice Stevens was noted for his bow ties. The story goes his father taught him to tie his shoes, and that transferred easily over to the bow tie, but he never could tie the other kind. Well, I can't tie any of them. So instead, I will slip on the justice's robe, and with that, become the spirit of his words as he introduces himself and his famous dissent.
All rise. The court is now in session. The Honorable Justice John Paul Stevens presiding.
Please be seated. Thank you. Good evening. My name is John Paul Stevens. Chances are you don't know me. But if you do, you might recall a rich kid from Chicago, always dropping names. Charles Lindbergh, Amelia Earhart. I really did meet them. Babe Ruth. I actually saw him play in the '32 World Series, Wrigley Field. Pointed his bat at that center field fence and smacked the pitch out of the park. It really happened. In World War II, I worked in naval intelligence. We all wanted to nail Admiral Yamamoto. He planned the attack on Pearl Harbor. We decoded secret Japanese messages that told us when and where he would be, and sent out a flight of P-38s in a beautiful job of long-range planning. They intercepted Yamamoto's plane right on the button and shot it down. We nailed him, all right. You're thinking, ancient history. Dead is the Roman Empire. Why all this nonsense? Because I need to tell you something big. And you won't know what it means unless you know something about me. The more the better, up to a point. So here's just a little more prefatory nonsense. I got a degree in English at the University of Chicago. At Northwestern, after the war, a law degree on the GI Bill. Had the highest grades ever recorded there. Not that it matters. I just wanted to mention it. Like so many bright lawyers, I spent a year in Washington as clerk for a Supreme Court judge. Joined a good firm back in Chicago, practiced antitrust. Returned to Washington, counseled a House committee on monopoly power. Back to Chicago, where a bunch of us started our own firm, and I made my name as an antitrust litigator. President Nixon made me a circuit court judge. When the great William O. Douglas retired, President Ford put me up as his replacement on the United States Supreme Court. The Senate confirmed me, 98-0. That was 1975. After 34 years on the bench, just before my own retirement, I wrote a dissenting opinion that could be my claim to fame. At least that's what they tell me. You know, it's funny. So many minority opinions wind up in the history books. It's like it's good to be in the minority. Anyway, that's what I want to talk about. What? Am I still a Republican? No comment. Now, my dissent's formal title. Opinion of Stevens J., Supreme Court of the United States, Citizens United Appellant versus Federal Election Commission on appeal from the United States District Court for the District of Columbia, January 21st, 2010. The three on my side were Ginsburg, Breyer, and Sotomayor. So the other side won a close fight. In a way, the fight concerned an outfit, Citizens United, that had a beef with the Federal Election Commission. But the Supreme Court can be pretty devious, and this was one of those times. Peel off one layer, and what do you see? We see another fight, 20 years old, that the other side lost and they never got over it. They've been sore ever since, waiting for a chance to get even. That old fight was called Austin versus the Michigan Chamber of Commerce, 1990. You see, the state of Michigan had this campaign finance law, said that corporations could not use Treasury money to support or oppose political candidates. Well, the Michigan Chamber of Commerce challenged that law, and the case went up to the United States Supreme Court. We said the Michigan law is fine. It does not violate the First or 14th Amendment, free speech, due process, equal protection. We affirmed that the state had a compelling interest in fighting a special kind of political corruption. Look, we said, our country has enabled corporations to aggregate huge piles of money, and the country got a lot in return. But we can't interpret those huge piles of money as public support for the corporation's political ideas. The corrosive distortion by corporate money is the special kind of political corruption we're talking about here. And the state does have a compelling interest in combating it. That's what we said in the Austin case. And Austin built up 20 years of good, useful precedent. But a stalker was out there, a big game hunter lying low, waiting for a chance to knock off Austin. Time passes. The 2008 election comes along. Hillary Clinton and Barack Obama are fighting it out in the primary season. Citizens United shows up. It's a corporation, a wealthy nonprofit that runs a PAC, a political action committee, with millions of dollars to spend. Now, can it spend that money just any way it pleases? Is it the Wild West? Of course not. Congress has passed laws that regulate the financing of political campaigns, such as the Federal Election Campaign Act, 1971, McCain-Feingold, 2002. Now then, Citizens United has this anti-Hillary Clinton film, and they want to use their corporate money, their corporate treasury, to finance their broadcast the month before the final primary. The Federal Election Commission says no. It's against the law to do that so close to the primary season. It won't allow enough time to answer an attack. And the court recently affirmed the law in question in McConnell versus Federal Election Commission in 2003. But the court's not what it used to be. Clarence Thomas joined in 1991, 1 year after Austin. Roberts and Alito, 2005 and 2006, 2 and 3 years after the McConnell case. Can Austin be in trouble? Does that patient stalker have it in the crosshairs? Is Austin the oblivious stag grazing in the meadow? It should not be. The parties to this dispute should have resolved their difference without toppling any statutes or precedents. They could have carved out an exception very easily. It's done all the time. the thing in dispute is only a film, just a pay-to-view TV show. But the majority of this court had buck fever. They were so hot to bring Austin down, they went ahead and broke a cardinal principle of judicial process. If it is not necessary to decide more, it is necessary not to decide more. Yes, they were even ready to violate the most transparent principle of judicial process, stare decisis, respect for precedent. Now, I'm not an absolutist on stare decisis, in campaign finance or anything else. No one is. But if it's going to mean anything in the rule of law, respect for precedent demands, at the very least, a significant justification for overturning settled doctrine, something more than the preferences of 5 justices. To quote an earlier court, a decision to overrule should rest on some special reason over and above the belief that a prior case was wrongly decided. There is no such justification in this case. This court's central argument is we do not like Austin. This Citizens United ruling will do a lot of bad. From now on, corporations and unions can empty their treasuries on ads that support or attack specific candidates with no disclosure of source. Soft money. But national parties cannot spend one thin dime of soft money on ads of any kind. This ruling inflates the role of corporations and unions and the narrow interests they represent relative to the role of political parties and the broad coalitions they represent in deciding who will hold public office. And that's just one thing these 5 judges have done in their revisit of Austin. Did Austin need reform? We've had it for 20 years. We've had over 50 years with similar statutes that this court suddenly calls into question. Have they been bad law? The court offers no evidence of that. No one says they don't work. No corporation has asked us to overrule Austin. No union, no state. On the contrary, leading groups from business, organized labor, the nonprofits, and over half the states have urged that we preserve Austin. What then has changed since we adopted Austin? The one relevant change is the composition of this court. So, today's ruling strikes at the vitals of stare decisis. So what, you say? Well, why the big deal? Well, many courts have told us why. One has said that stare decisis, respect for precedent, is the means by which we ensure that the law will not merely change erratically, but will develop in a principled and intelligible fashion that permits society to presume that bedrock principles are founded in the law rather than in the proclivities of individuals. All right. All right. What about the merits of this ruling? Did Austin kill corporate speech? Does the First Amendment forbid regulatory distinctions based on who's doing the speaking? In other words, does the First Amendment forbid different rules for different speakers? Does Austin betray our First Amendment tradition? Our tradition of campaign finance law? Look, when Citizens United brought suit, the lawful restrictions on speech were so pitifully few that it was simply nonsense to say that corporations had been, and I quote, excluded from the general public. Corporations excluded? Come on. In the 20 years since Austin, corporations have played a major role in the national dialogue. The corporate voice has not been stifled. It threatens to drown out everybody else. Let's talk about the First Amendment. For over 200 years, our courts have rejected an absolutist interpretation of the First Amendment. It does say that Congress shall make no law abridging the freedom of speech or of the press. Yet, in various contexts, we have held that speech can be regulated differently for different categories of speakers. The government routinely places special restrictions on the speech rights of students, prisoners, members of the armed forces, foreigners, and its own employees. When such restrictions are justified by a legitimate governmental interest, they don't necessarily raise constitutional problems. If taken seriously, our colleagues' absolutist interpretation leads to some pretty remarkable conclusions. For example, in World War II, Tokyo Rosa's propaganda broadcasts to our troops in the Pacific would have had the same protection as speech by Allied commanders. Yes. And multinational corporations controlled by foreigners would have the same speech protection as individual Americans. Yes. And if voting is a form of speech, our colleagues should declare a First Amendment right on corporations to vote, to cast a ballot, to cast a ballot. In short, the court dramatically overstates its critique of distinctions based on identity. And it never explains why corporate identity demands the same treatment as individual identity. Oh, for God's sake, only a wooden hand could use the First Amendment to draw a line so straight, so innocent of precedent. This court invokes what it calls ancient First Amendment principles to defend today's ruling. But it makes little reference to the thoughts of the framers who drafted and ratified the First Amendment. Why? Maybe because no framer thought the First Amendment would forbid regulation of companies. To the extent that we can discern the framers' views, those views actually undercut the majority's position. The framers conceived of speech more narrowly than we. And they thought differently about the social role of corporations. Those few corporations present at the founding of our country were authorized by individual grant of a special legislative charter. If amenable, the legislature would issue a charter that specified the corporation's powers, purposes, scope, and structure. Corporations were created, supervised, and conceptualized as quasi-public entities, entities to serve a social function for the state. But their legally granted privileges came at a price: close legislative scrutiny, intended to keep their purposes in harmony with the public welfare. This view of incorporation reflected the cloud of disfavor that beshadowed the early corporations. They were called evil, soulless. They concentrated the worst urges of whole groups of men. Thomas Jefferson famously fretted that corporations would subvert the republic. Not until the later 1800s did we have general incorporation statutes and widespread acceptance of business corporations as socially useful actors. The framers assumed that we could regulate corporations in the service of the public welfare. Unlike our majority colleagues, they easily distinguished corporations from human beings. When the framers constitutionalized the right to free speech, it was the free speech of individual Americans they had in mind. Individuals might exercise that right alone or together, but business corporations, they had nothing to do with that. A corporation invoked the First Amendment. A corporation invoke the First Amendment? The framers would have laughed out loud. They all knew that if you wanted to legitimize any corporate activity, you had to have a concession from the sovereign. In the words of one framer, Chief Justice John Marshall, "A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of its creation confers upon it." Given these background practices and understandings, we cannot believe that the framers would have extended freedom of speech to corporations. We cannot believe that the founders' freedom of speech would free corporations to capture our elections. History shows that today's ruling violates our First Amendment tradition. In 1905, President Roosevelt told Congress, this is Theodore Roosevelt, Teddy, in 1905 to the Congress. "All contributions by corporations to any political committee or for any political purpose should be